and 23 CR 508, two indictments style the state of Texas versus Gabriel Jones, who was charged by indictment of a grand jury in each case with the second-degree felonies of aggravated assault with a deadly weapon. All parties are present, and the jury is also present in the courtroom. Ms. McKee, I understand you are the jury foreperson,
Yes, sir.
and we have received a message on behalf of the jury that the jury has reached a verdict or verdicts in these cases. Is that true?
Yes, sir.
Is the verdict or verdicts unanimous decisions? That is, ones that are agreed upon by all members of the jury?
Yes, sir.
Do any of the jurors disagree with your foreperson's representations? No disagreement is indicated, and it does appear clearly that whatever decisions the jury has made in these two cases, in each of these cases, are unanimous decisions. If you would be so kind, pass the documents to the bailiff. You may be seated. The court will review for proper form and publish the verdict or verdicts. And the court will note we have two verdicts in one for each of these cases. The defendant shall rise. In cause number 23, CR 507, the indictment style, the state of Texas versus Gabriel Jones. As to cause number 23, CR 507, we, the jury, find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment. And this decision is signed by the jury foreperson. It is made a part of the record for all purposes. Cause number 23, CR 508, the state of Texas versus Gabriel Jones. The verdict reads as follows in this case. As to cause number 23, CR 508, we, the jury, find the defendant not guilty of the offense of aggravated assault with a deadly weapon as charged in this indictment. Signed by the jury foreperson. These decisions and verdicts are received and made a part of the record for all purposes. And the parties may proceed. At this time,
this split verdict perfectly illustrates how complex aggravated assault cases can be. Gabriel Jones is found guilty on one count and not guilty on another, both involving allegations of aggravated assault with a deadly weapon. In plain terms, the jury determined that the evidence met the legal standard in one incident, but not in the other. It's a powerful reminder that jurors evaluate each charge independently, guided by facts rather than emotion. So what do you think? Does this feel like balanced justice, or does it raise questions about consistency?
ladies and gentlemen, I have received the decisions made by the jurors in each of these two cases. And 508 is closed. We will continue proceeding with cause number 23, CR 507, the second-degree felony of aggravated assault with a deadly weapon, for which the jury has found the defendant guilty. Please remember, you are still under all the instructions the court has given to you. At this time, I'm going to ask the state's attorney to please refer to cause number 23, CR 507, the indictment that the defendant has been found guilty of by this jury, and the defendant shall rise. I'm going to ask the state of Texas to please read into the record before all parties the second paragraph in this indictment to this case, and the state may proceed.
And the grand jurors aforesaid, upon their oaths aforesaid, do further present in and to said court at said term that before the commission of the primary offense, the defendant was finally convicted of the felony of assault, family violence, third degree, on January 12th, 2018, in cause number 15-23191 in the 252nd District Court of Jefferson County, Texas, against the peace and dignity of the state, signed the foreman of the grand jury.
Gabriel Jones, as defendant in this case, you have just heard that the state has read paragraph 2, which alleges by the grand jury presentment that you were finally convicted of the third-degree felony of assault family violence on January 12, 2018 in cause number 15-23191 in the 252nd District Court of Jefferson County, Texas, next door. Do you understand, Mr. Jones, what this states?
No.
You don't understand?
No.
Do you understand English?
Yes.
Okay, is there something about this that I didn't, that you were?
And now the moment that raises the stakes dramatically. The court confirms that Jones has a prior felony conviction, assault family violence from 2018. That single fact changes the entire sentencing landscape. Under Texas law, prior convictions can significantly increase penalties and restrict the judge's ability to show leniency. The judge's calm tone masks the seriousness of this revelation. This isn't just about today's verdict. It's about the weight of past actions catching up. The question now is simple. Does Gabriel Jones fully grasp what comes next?
Confused about? Have you had a chance to speak with your attorney about this?
That's what he's asking. Oh, yes, Your Honor.
Okay, so sometimes people get confused.
I totally have.
Do you you've heard what was just read?
Yes, Your Honor.
Is that allegation that you have made by the grand jury in paragraph 2, which states that you were previously convicted in 2018 in that case that I have described of assault family violence, a third-degree felony?
Yes, Your Honor.
Is that true and correct as it alleges?
Yes, Your Honor.
Are you pleading true and correct to that allegation voluntarily and because it is true as it states?
May I ask a question, Your Honor?
Ask him. Y'all speak quietly. Yeah, don't go to me first. Go to your lifeline. Is that allegation true and correct? And are you pleading truth and correct to that voluntarily and because it is true as it is alleged?
Yes, Your Honor.
All right, you may be seated. Or we'll enter a plea true to that allegation on this day. All right, as we talked about, criminal cases are a bifurcated system. We have one part 1, guilt or innocence. And if guilt is found, then we go to part 2, the punishment phase. And each party gets an opportunity to present information to help the jury decide what the punishment should be, which is their domain, since the defendant has elected to have you, the jury, make the determination of punishment if he is found guilty on one or more of these cases. The other indictment, since he was found not guilty, there will be a judgment entered, signed by the court dismissing that case. So we will proceed here after lunch on 507 for the punishment phase of the trial, ladies and gentlemen. And again, you're still under all the instructions the court has previously given to you. Can the parties be ready at 1:15? That gives you about an hour, 10 minutes.
Yes, Your Honor.
All right, state and defense. All right. We're going to take a break, ladies and gentlemen. Again, the same instructions as yesterday. And if you go to lunch, if you go with some of the jurors, talk about the weather and sports or the elections, anything, but not about this case. Okay, thank you very much. And again, the same instructions for the alternates. We'll see you back at 1:15. Thank you very much. Everyone else remains seated while the jury exits first.
Roll it. I just placed a flat. No. Okay. One more time. Same one. Then do it right here. Yeah, go sit next to the attorney.
And we now recall clause number 23 CR 507, the state of Texas versus Gabriel Jones. The court has received a message from the jury that the jury has reached a verdict in the second or punishment phase of the trial, and we will call forth the jury and receive their verdict. Thank you. All parties are present, including the defendant. And the record shall note that the jury is seated in the courtroom. And on behalf of the jury, Madam Foreman, we have received a message stating that the jury has reached a verdict in this second phase of the trial. Is that true?
Yes, sir.
Is this verdict a unanimous one? That is one that is agreed upon by all members of the jury?
Yes, sir.
Do any of the jurors disagree about your four persons representations? No disagreement is indicated, and it does indeed appear to be unanimous. If you would be so kind, pass the verdict form to the bailiff. You may be seated, and the court will review for proper form and publish the verdict, and the defendant shall rise. In cause number 23, CR 507, the state of Texas versus Gabriel Jones. We, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 15 years. It is signed by the jury foreperson. It is received. It is made a part of the record for all purposes, and you may be seated. Ladies and gentlemen of the jury, at this time, I have received and accepted your verdict, not only finding the defendant guilty of the offense of aggravated assault with a deadly weapon, but also finding that the punishment in this case should be assessed at 15 years confinement in prison. At this time, your duty as jurors is completed. At the beginning of the trial, I placed you under a number of instructions. At this time, I'm releasing you from these instructions. However, a couple of instructions. Number one, once you are discharged, you are released from your oath of secrecy. You are free to discuss the case in your deliberations with any. You are also free to refuse to discuss the case, and you have every right to maintain your silence unless otherwise ordered to do so by the court. Once you are discharged, we have some formalities that have to be accomplished in closing out this case, and the court has to make some findings and rulings of law, and a judgment will then become prepared, and that will be entered into the record. But in just a few minutes, the attorneys are going to be released, and they always like to get feedback if you are willing to talk to them. Sometimes they can answer questions that you might have about how, why things happened, and get their feelings about things. And you are also free to discuss these matters now with anyone. You are released from your oaths of secrecy, and you are also free not to discuss this. I got a note about someone wanting to talk to me. I am, if you want to speak to me, I'm going to be able to speak with you. I just can't speak with an individual juror in the middle of a trial without others being present, the parties. We call that ex parte, which is inappropriate. Unless, of course, there's a life-threatening event happening, but I didn't get that impression. It was, but it may have been something that you need clarification on, and I'm happy to spend some time to discuss that with you if you wish, whoever that is. Once again, these issues aren't supposed to be easy. They're difficult because we are making judgmental decisions on our fellow man. Judge not, lest ye be judged. Remember, that's in the New Testament. But then again, the burden of proof beyond a reasonable doubt was all coming into play so that jurors can have a standard. That is a rule of law that we have, since this is the most humane and modern form of determining issues amongst ourselves when the rules of law and behavior have been breached. And it's not supposed to be easy, but it's important that we deal with them responsibly and under the law and fairly. And I I want to thank you for the time and your attention that you took to doing your job as jurors. I also hope to have the honor to work with you in the future. And until that point in time, may God continue to bless Jefferson County and her citizens. And you are about to be excused. Ellie over there has documents if you need them for work or school or other purposes. And the lawyers are going to be out in a few minutes, and they can also answer any questions that you may have, why things were done in a certain way. But I'm going to release you, and again, thank you. It was an honor working with you. And I hope to have that honor to work with you in the future. You are excused. Thank you. And alternates, y'all are in the bullpen, ready, willing, and able to go. But thank you again for being there, because if we don't have alternates, if we lose one person, it's a mistrial and we have to start from square one, and we don't have the wherewithal. This is about jury number 6. We're at 596,
Yes.
something like that. I mean, we don't have the ability to retry cases. We've got to keep plowing forward, like Patton did in World War II. We just have to keep going forward. We have no time to turn around or stop. But all of us doing the right thing together as the rules provide in a responsible way, and it gets done. So thank you very much. You are excused. And is there any reason why formal sentencing and a judgment being orally assessed and then placed into a written form should not be made at this time?
No, Your Honor.
Y'all can all be seated. Gabriel Jones. In this cause number 23 CR 507, you came before this court in a jury, entered a plea of not guilty to the offense of aggravated assault with a deadly weapon as charged by the jury. The evidence was submitted. The jury was charged by the court of the law. After deliberating, the jury returned a verdict finding you guilty of this second-degree felony of aggravated assault with a deadly weapon. Thereafter, in the punishment phase, evidence was introduced into this case where you had previously been convicted of a third-degree felony of assault family violence in 2018. And based upon the jury instructions, after evidence was presented, the jury went back to deliberate and deemed that the appropriate punishment in this case should be assessed at 15 years confinement in prison. Is there any legal reason why sentence should not now formally be pronounced against the defendant?
No, Your Honor.
Therefore, it is the order of this court that you, Gabriel Jones, who has been adjudged to be guilty in cause number 23 CR 507 of the offense of aggravated assault with a deadly weapon, and whose punishment has now been assessed at 15 years imprisonment in the Texas Department of Criminal Justice's Institutional Division or prison, you shall be delivered by the sheriff of Jefferson County, Texas, to the director of the Texas Department of Criminal Justice's Institutional Division or any other person legally authorized to receive such convicts, where you shall be confined for 15 years in accordance with the laws governing the Texas Department of Criminal Justice's Institutional Division. You are here now remanded to the custody of the sheriff of Jefferson County, Texas, until she can obey and carry out the directions and instructions in the sentence. Your sentence commences this day. You will receive credit for all time periods of detention as provided by the law that you were placed in a direct relation to this case. Also, the judgment shall reflect an affirmative finding that a deadly weapon, namely a knife, was used in the commission of this offense. Is there anything to add by the parties, state and defense?
No, Your Honor.
Then we are in recess.
And with that, the sentence is handed down. 15 years in the Texas Department of Criminal Justice. The jury sends a clear message. Aggravated assault with a deadly weapon carries severe consequences, especially when paired with a prior violent conviction. In closing, the judge reminds the courtroom that justice is never easy. It requires balancing accountability with humanity. Whether you believe this outcome was fair or too harsh, this case powerfully shows just how narrow that line can be. If this courtroom moment held your attention, hit the like button, share your thoughts in the comments, and subscribe for more gripping courtroom breakdowns and real legal insight, right here on Courtroom Files. Turishan.